hemp has many issues on how we adjust to the testing. We've forwarded a series of recommendations from the Oregon Commerce, which I think is similar to the Kentucky Commerce in hemp, regarding the flexibility on the how many days out from harvest you test, what part of the stem you test, and a lot of these come down to questions on whether you go over the 0.3 standard or don't, and millions of dollars of crop is out there. These are very different crops from the 14% plus THC. So clearly they're hemp, but there's been a lot of concern that the design of the rules is designed to make it very hard to farm hemp. And I don't think that's the intent, but we need to work with your team to get a little more flexibility, because clearly if there's 0.3 or it's 0.4, it's still clearly hemp, not cannabis, if you will, recreational cannabis.
Certainly true. I think while we fought for a little more flexibility of widening those standards, I believe statutorily the law was constrained on that 0.3. You may know also in the regulations that we had some pushback from DEA that really didn't like the whole program to begin with. And from a lab testing and others, we made a few modifications as we were able to under the legal statutes in our interim final rule. This is a new, unusual crop, as you understand, and we'll be very open to ongoing comments as we go forward about what those other flexibilities, and make sure that we make it as available as possible for people who want to grow hemp in that regard. But our hands were constrained many times by the interagency process of other people weighing in.
Yeah, and it isn't so much the statutory concern on the 0.3 as it is the rules of exactly how you test, because that
certainly.
So we'll work with you.
Okay.
I think it's very clear this is hemp, not marijuana. We need to make that clear to the DEA community, and
sure.
And thank you.
Right.
Senator Leahy.
Thank you, Mr. Chairman and Secretary Perdue. Thank you for appearing today. I've shared Senator Merkley's concerns regarding the department's hemp rule. It is a crop, and I urge you to continue working with us to get it right.
Thank you, Mr. Secretary. I want to return to the hemp issue. It was potentially $1 billion crop in my state, and therefore it's of great attention. In fact, if it hit that, and it depended on the drying and the processing, it would have been the largest agricultural crop in the state of Oregon last year. Under the interim production rule, a couple pieces. Your department has said they would delay enforcement of over the disposal portion of the rule, and a requirement of using DEA labs because there weren't labs. That was one of the comments that I had forwarded back to you.
That's right. Those are the two things that we were able to do.
And that the USDA is going through a 2-year process of evaluating the information on the interim rule to develop a final plan. Is it appropriate to refer to this interim rule as a draft plan, given the evolving changes in the evaluation?
I would think you would. The problem is on an interim final rule, as our lawyers have explained to me, once it's set, unless there are minor changes in that, you can't change it until you go to the notice of proposal rulemaking. What we are, I would functionally say it's a draft plan. This is a very unique crop, as you know. We were learning as we were going, and we tried to nail it best we could. We had some pushback, as I indicated, in other agencies, but I would think your characterization of a draft is a good one.
This goes to a question about the states that are under the 2014 hemp pilots, because the language was that they could be under the pilot until 1 year after the Secretary establishes a plan. And whether you interpret that as a draft plan or a final plan affects the 2021 growing season. The 2020 growing season, I think everyone agrees, can be under the hemp pilot, 2014 hemp pilot. But it would be very helpful to the states of Kentucky, Oregon, North Dakota, Colorado, Vermont. There are about 10 states that are still hoping to operate in the 2021 growing season under the 2014 rule, so we can work out these issues I was raising, the 15 days, how much of the exactly what part of the plant you test, whether or not you count a molecule that is being counted as THC that isn't quite THC. There's a series of things that could turn 0.3 into 0.4 and have people destroying very valuable crops that are clearly hemp crops. And so I wanted to work with you to see if we can get those states an additional growing season as we work out the details around this.
Senator, my preference would be to resolve the issues from our federal rule, if we can, by that 2021 growing season, certainly from the Oregons and the Kentuckys that have had experience in this crop. If we cannot, I will be absolutely as flexible as the law allows in order to perpetuate the 2021 under the state rules of 2014 in that area, if we can't resolve the main issues that the states that had those 2014 laws resolved.
That'd be very helpful. Thank you.